Yes. Ingraham versus Wright by Ryan, Prairie, and Heather. Were you ever taken to the principal's office to receive corporal punishment for misbehaving in school? Many students never have to experience corporal punishment, such as spanking and receiving lashes. For James Ingraham and Roosevelt Andrews, this was not the case. They both received corporal punishment in a Dade County, Florida, public school. Ingraham received an alleged 20 licks from a wooden paddle that the principal possessed to use in cases of disobedience. Ingraham's injuries caused by the beating led to many bruises and even serious hematoma that required special medical attention. This kept him from returning to school for several days. Andrews also received punishment, and it was so severe that it caused his arms to be unusable for nearly a week. Both Ingraham and Andrews petitioned their case before the Southern District Court in Florida. They argued that the corporal punishment that they had received while attending the Charles R. Drew Junior High was cruel and unusual. With accordance to the Eighth Amendment of the United States Constitution, it was not allowed. Their case became known to the United States Supreme Court as Ingram versus Wright in 1977. Willie J. Wright was the principal of the school where the boys received corporal punishment. Wright denied the number of licks was 20 and said it was closer to the allowed 5. According to the state law of Florida at the time of the incidents, public schools are allowed to give 5 licks of corporal punishment by a wooden paddle that is no thicker than 1.5 inches, 2 feet long, and 4 inches wide. The United States Supreme Court decided in a 5-4 decision that corporal punishment in public schools did not violate the Eighth Amendment of the United States Constitution. The question that was being asked was, does corporal punishment violate your Eighth Amendment rights? The court argued that the Eighth Amendment did not apply to public schools, though, because the Eighth Amendment applied only to the criminal system in the application of fines, bails, and punishment. After determining this, the court ruled in favor of the school that Ingram and Andrews attended, saying that they did not violate the children's rights by giving them spankings. Bruce Rogo, Ingram and Andrews' lawyers, argued that the Eighth Amendment was adopted by the United States when there were few public schools that existed, causing the people to not consider the application of the amendment toward the schools. The court denied his argument and stayed with their decision. Rogo also argued that the court had to allow kids a chance to defend themselves in a hearing before the school was able to give them corporal punishment, because according to Goss versus Lopez, schools must provide children a time to explain themselves before being expelled for a certain time. Once again, the court denied the claim. The decision by the United States Supreme Court on April 19, 1977 has impacted many kids today. The decision allowed schools to administer corporal punishment to disobedient children. After the decision was made, only 2 states outlawed corporal punishment, and in the 1990s, 21 schools followed suit as an uprising in opposition to corporal punishment occurred. Since the decision, many schools have had to discover new and creative ways of punishing children. The next time you're sitting in the principal's office and he tells you that you have to serve 2 days of ISS or in-school suspension as your punishment, lean over and thank him for not giving you 20 swats of a paddle.